and statements following program do not necessarily reflect those of WWDB, its staff, or management.
All right, ladies and gentlemen, Joe Dougherty. Welcome to the Pain and Wellness Hour with Sonny Banks. I'm your co-host, Joe Dougherty, on WWDB 860 AM. We got a phenomenal show for everybody today. We're sponsored by Weineman Pain and Wellness, serious doctors for serious injury. Sonny, how are you, sir?
Very good, Joe. Beautiful day today.
Absolutely. Fantastic summer day. It's great. I'm happy to be able to be in the studio. Certainly, I can't wait to get us both in here and our guest. But we do have a phenomenal show today. If you would, introduce our guest.
We have Philadelphia attorney Faye Riva Cohen with us today. Faye operates her own law firm, which is located at 2047 Locust Street in Philadelphia. She's been in practice for over 40 years. In fact, Faye's firm was one of the first women-owned law firms in Philadelphia. Faye's firm focuses on employment and labor law, civil rights litigation, estate planning, real estate, and family law. The mission of the law firm of Faye Riva Cohen is to provide aggressive, sophisticated legal representation in complex cases in their practice areas. Their small size allows them to devote resources that are necessary to go up against big insurance companies and corporations rather than worrying about the stifling overhead. The law firm of Faye Riva Cohen treats each case they handle as if it were their first case, their only case, which ensures clients receive personal, focused attention. The law firm of Faye Riva Cohen has decades of experience, which gives them the knowledge to maximize results. Faye, if you would, please tell our listeners about yourself and your law firm.
Well, thank you, Sonny. I very much appreciate that introduction. I will have to hire you as my PR person. The matters that I really enjoy helping people with are issues regarding disability and civil rights. And these days, those particular issues are often a minefield, and it is very difficult for lay people to be able to walk through that minefield without some legal assistance. So, for example, I often encounter clients who have issues regarding medical accommodations through the Americans with Disabilities Act. They also have issues dealing with workers' compensation. They have issues dealing with family medical leave. They have issues because they might have been terminated when they filed a workers' compensation claim, or they raised disability issues. And so those are the types of things we encounter. And on top of that, these days, we have the COVID-19 overlay, which is a very large overlay. So those are the types of areas that I feel are very helpful to everyone.
And Faye, how is your practice broken down in terms of what you do more of?
Well, what I primarily do, and I'm known for in the litigation area, are labor and employment issues for both plaintiffs and for small companies and offices. So, for example, if someone comes to me and they say, I need some family medical leave time because I'm having surgery, and I'm having problems getting that leave, or when I return from that leave, I want to make certain that I'm able to go back to my job, or I'm able to be accommodated in some sense. I help in that area. We also have a very significant estate and elder law practice, and that jives with disability issues also, because everyone should have 3 documents, a will, a power of attorney, and a health care declaration, which is sometimes called a living will. We also have a large family law practice, and that is significant also. I feel these days it's important to have a firm, be connected with a firm, or have a referral network with other firms where we can help the entire individual. back in the original inception of lawyers, you had a family lawyer, and that lawyer handled everything for your family. These days, clients can sometimes have to consult 5 or 10 lawyers to get the same type of information, and because lawyers have become so specialized and because law has become so complicated, it's good to know people that are in your referral network and can assist you.
So it's pretty courageous of you to decide to start your own firm. The obvious struggles that come with that, coupled with the fact that you're a woman. Why did you decide to go that route?
Well, I've always been a very aggressive individual. My background is my parents were Holocaust survivors, and I was actually born in Bergen-Belsen, which was a relocation center after the war. It was a concentration camp before the war, and it's a camp that Anne Frank died in. So
Wow.
we immigrated when I was 2, and we immigrated to Minnesota. So I grew up in Minnesota, and people in Minnesota were a little more laid back then, so I moved to the East Coast. It suited my personality better. And I honestly never thought there was nothing that I couldn't accomplish. I had some good mentors. I was the first woman who actually practiced with large law firms as a contract lawyer while my 2 children were very young, and then went out on my own at some point. And I've enjoyed working on my own. I didn't think it was that unusual, but when I read about the things that women have encountered in the profession and just going through it myself, I do think it was unusual, and I think the background and my background gave me the courage to step up.
Faye, when it's interesting because and some you're blazing your own trail when you started your own firm, but when you got first into the business and you were working for somebody else, were there any experiences that motivated you to go out on your own? Was it very difficult? I mean, obviously it was a man's world at the time. Were there experiences that negative and positive, that motivated you to go out and do it yourself?
Well, I wouldn't say necessarily motivated. I was practicing at the time with a firm called Cohen Shapiro, which is a very well-known firm, and the litigation of that firm, the litigation department actually split in half, and there were some very well-known attorneys working with that firm at that point in time. So because they split in half and I wanted to go in a different direction, I joined at that point someone who is since became my ex-husband, but we developed real estate and we practiced law, and then eventually I practiced law on my own. So there weren't any significant experiences, although I was practicing some very significant civil rights law. I was actually the attorney who helped Alan Lerner at the time, was a very well-known attorney. He's since passed on. His brother was Benjamin Lerner, the judge. And we handled the first age discrimination cases in the country. And it was quite interesting. They were significant laws. We worked with the EEOC on some cases. We worked on civil rights cases. We worked on the age cases. We worked on gender cases. And I think it was that background that motivated me also when the firm litigation department split in half. That motivated me to go into that area of the law, which is not an easy area of the law. It's a difficult area of the law. We're always fighting on behalf of average people against big corporations, big universities, big business, and so you have to be a fighter, and I am a fighter.
Faye, did you have a particular mentor, female or otherwise, that kind of directed your path in the law?
Well, when I started, there really were not many female mentors. There were just a few women practicing. Some of them became quite prominent, became heads of bar associations and federal judges. But Alan Lerner was one of my first mentors. I also practiced with Stephen Scheller, who became a giant in the legal field.
Yes.
And also Leo Serena, who was a judge, became the president judge in Delaware County. And so they were my mentors.
Go ahead, Sonny.
Joe. No, go ahead.
So, having said that, you mentioned, so I was on your website, and what I really like is I see the blog, and I don't know if you had a chance to see that, Sonny, but the blog is it's called the Tough Lawyer Lady Blog, and
yeah, it made me laugh.
Yeah, no, it says obviously about your fighting and your with for your clients. What can your clients expect when they retain you? Because like you said, sometimes you're fighting Goliath. It's David versus Goliath. What would you want your clients to know about yourself when they retain you?
Well, I want them to know that they have 46 years of experience behind them. They have someone who can look at their facts and empathize with them. However, I want to make certain that I feel they have a valid case. I need my clients to understand that the law is based on individual situations. It's based on individual judges. It's based on a certain facts and circumstances. And just because you read that someone got millions of dollars over the internet in a case that happened in Ohio or California, it doesn't necessarily apply to this area. In fact, this area is a very difficult area. There are only about 10% of all civil rights cases that actually prevail. Many of them are settled, but this is a hard area of the law. Plaintiff's employment is a very hard area of the law. So if the client comes to me and I am certain that they are realistic about their expectations and we can get them what we think we can get and what is fair, we will fight for them as hard as we can. And we're in federal court constantly. We deal with every agency. We deal with the Merit System Protection Board. We deal with the EOC. We deal with the Pennsylvania Human Relations Commission, the unemployment compensation agencies, all of them. But people have to remember, whoever you're dealing with, they are quite often being paid by the government. So your referees and your judges and so on, the odds are quite often stacked against you. But I think we get very good results. And if clients' expectations are where they should be, they'll be fine.
Yeah, Sonny, before I'd like to follow up on that.
Sure.
You talk about expectations in a couple ways. You said a couple of things. So do you set those expectations right from the get-go, number one, and how important is that to kind of walk somebody through what they're up against and what the situation is at the beginning? And that's the first part. And then the second part is you mentioned you're often dealing with a situation where you're dealing with the federal government and you're dealing with federal judges, and certainly in some cases politics may impact the law. I wanted to get your opinion on politics and the law in regards to that and how it changes literally judge by judge. But let's first talk about expectations.
Well, there are two parts to every case. The one part is what happened, and many clients want to just talk about their situation and how they feel they've been damaged. And remember, in the employment area, they haven't often been physically damaged. Possibly they may have some psychological or mental health issues because they've become depressed or developed post-traumatic stress, but it's not as if they've suffered a severe physical injury. So we're not really talking about the same types of damages and pain and suffering. So they talk about their case, and they like to do that. But then when I ask them, well, what do you want as far as expectations and damages, they're very often stymied by what they want. They seem to get stuck on just telling their story. They want their day in court. You need to know what your damages are, and you need to be realistic about what the laws provide as far as damages and about what you are going to receive. So if you have been terminated from a job, but then you got another job and you're losing $2,000 a year, your damages are not millions of dollars. I mean, they have to be fairly realistic expectations. Right. Plus, many people say, I want to go after my former employer, but I don't want to return there to work. So what I say is, so in other words, you want someone to hand you a pile of money, but you don't want to return there, and they say, well, the law says I can get such and such. But as we all know, what the law says and what the law does are two different things. And
Absolutely.
as far as political issues are concerned, these days what I'm finding with the federal government is being very tough on people who are terminated, and they are not bringing them back. They are not agreeing to give them a clean record so that they can get a job with another government agency, and they are offering a very small amount of money. So the president's philosophy that he has written about in his books and so on, and his interest in litigating issues, that is the current philosophy of the federal government. So if you want to oppose the federal government now and you're an employee, it's a much harder road to hoe and an uphill battle than it was years ago when things were fairly regularly settled, some decent amounts of funds or lost wages were offered, and your record was cleared so that you could look for a job with a government agency. That is not happening these days.
Sonny?
Faye, how do you see the area of civil rights law evolving following the George Floyd incident and, the Black Lives Matters movement taking off?
Well, I feel civil rights is going to be a huge area of the law. It is a huge area in many respects, but I think it has to be couched in the same things that we've been trying to deal with for many years. How do we actually apply civil rights, and how do we get the idea when I say civil rights, I don't always mean race, I mean gender, I mean religion, I mean disability, all of these issues, and they all deal with civil rights. Right. So in order currently for someone to bring a civil rights case, they are usually required within a very short period of time, between 180 days and 300 days, to file a complaint with the government agency. Those agencies are very overworked and understaffed, and sometimes you're not dealing with people beyond the clerk level. And so I tell people who are going to file with an agency, do not have high expectations. At some point in time, you will have to possibly make a decision whether you're prepared to go to court or not. And it's extremely expensive to go to court. Even if you find an attorney who is willing to take a case on a pure contingency fee level, which isn't always the case, the costs are extremely extensive. So we have to do, a balancing situation about how much did you actually lose, because who's going to put in $50,000, $60,000 of costs if you've lost $10,000? So I feel it's going to, civil rights is going to explode. I think people have to be realistic in their expectations about what the law and the government can do for them, because we are still dealing, at least in the civil aspect of civil rights, it's a moneyed system. Someone has to put forth the money to go to court. The lawyers have to do it, or the clients have to do it, but no one is going to court for free these days. So that limits, I think, where things can go. And other than that,
I was going to ask, do you think the structure of the federal court, the system, the process is ready for the explosion that you mentioned?
No, it is not ready currently. The other thing is, many people go to court pro se. That means they're bringing a case on their own. They have read somewhere that you can bring a case on your own, and a judge has to deal with you. The federal judges have a lot of work on their plate. They're quite astute. They're quite hardworking, but they cannot handle a tremendous amount of cases.
Right, just like any bureaucracy, they're understaffed.
They're understaffed. Now we're going to have an issue with jury trials with COVID, whether those are even going to be able to take place. There's going to be an issue about at the administrative level, because generally you have to at least start a case at the administrative level, file something with a government agency. There's a tremendous backlog with those. You know, we're talking about years and years here before we're going to catch up with this system.
You know, and I'll jump in when you mention, sometimes a misunderstanding or a misnomer that somebody, hears about a case, and they, somebody got, and it's an extraordinary case. I mean, but it sounds like what they're in the middle of. Obviously, you can't compare, apples to oranges. On a personal injury, it reminds me a little bit of that. What was I think it was McDonald's when the person's I think it was
right, the coffee. The
coffee, right?
Coffee.
I think coffee sales at McDonald's went up like tenfold. People were, dropping coffees on themselves like that, like it was going out of style.
Trying to hit the lottery.
Right, but circumstances obviously are not what they always seem. And having said that, Faye, if you would, let's talk about somebody who may be, a listener who may be going through something where they feel like their civil right, they're in work, and they feel like they're being discriminated against, for their race, their creed, their sex. What's the first thing they should start doing if they think for some reason that's happening?
Well, I don't think they should start an argument with anyone they work with and assume that if they walk out of their workplace or are terminated, they are going to have a wonderful wrongful discharge claim. Most employees in Pennsylvania are employees at will.
Right.
And I talk to so many people every day who are absolutely shocked that there really isn't wrongful discharge for the most part in Pennsylvania. So what they need to do is, before they get into an argument with someone, or they walk off the job, or they feel their employer does not have the right to control them, is arrange for a consultation with a lawyer. And if they want to call the Philadelphia Bar Association for a half an hour, they'll refer you to a lawyer. It costs $35. Or if you want to start, going through the internet, or if you want to call me, or if you want to call Sonny, or whoever you want to call, sit down with someone and get your facts straight. I cannot tell you how many people are terminated from jobs because sometimes their doctor says, they're not able to do their full-time job. The boss goes, great, you're fired, can't do the work. Or they turn around, they say, well, someone yelled at me, so I told them I'm going to take it outside, we're going to fight it out. Both of those people are terminated. So many of those instances, they don't have to lose their job, or possibly if they feel there's discrimination, they don't want to continue. Sometimes their employer doesn't want them there either. So I negotiate hundreds and hundreds of severance packages every year also. So there are things that can be done. Have all of your facts straight. Learn what the law permits that you can do and you can't do. And I'm sure all of us have heard at some point a client will call, potential client, they don't want to hear, they hear what they don't want to hear, and they say, okay, well, I'm going to look for a lawyer who knows what they're talking about. So I tell them, I know what I'm talking about after 46 years. You just don't want to listen to what I'm talking about. And sometimes they'll call me back a couple of years later. They said, you know what, I didn't listen to you. I went and filed a complaint. Nothing happened. I lost my job. I should have listened to you. So it's not that difficult. Get your information ahead of time. And don't assume that what you read is what the actual case is.
Faye, what does at will mean for listeners?
Well, at will means that an employee can be terminated for almost any reason, and I'll talk about the exceptions in a few minutes. But it also means that an employee is not an indentured servant or a slave and can't walk off the job. That used to be the case years ago. People had to work for the company, and the company sold them their goods, and they gave them a place to live. So they couldn't ever leave that job because they were indebted to the company. They couldn't accumulate enough funds, or they were in indentured servitude, or they were slaves. So that means that you can be terminated for almost any reason, and you can leave for any reason. Now, many employees go, well, I don't want to leave. So I said, but you don't have a lifetime job either. Those days have passed. Some people said, well, I want to stay till, I wanted to retire, so I am owed 25 years of damages. I said, it doesn't work that way. But the exceptions for employee at will is if you feel that you've been the victim of discrimination, that you can file a complaint with a government agency and possibly go to court. That's one big exception. There's another exception if you're covered by a collective bargaining agreement or you're a member of a union. You have a right to go through a grievance procedure, and if the union decides to mediate or arbitrate, you can go through that process. That's another exception. A third exception is whether it's a public policy violation. So, for example, if you are called to jury duty and your employer terminates you, then you have a public policy exception. And another exception is if you filed a workers' comp claim or mention that you might have a workers' comp claim or mention that you possibly were injured at work and you're terminated. That is another possible exception. So there may be other smaller ones, but those are the main ones.
Sonny, how about the workers' comp? Let's talk about the workers' comp situation, particularly because it kind of does overlap in both of your areas. Scenario, somebody's working, and by the way, I thought there was so we do a lot of labor shows, and that is definitely a situation that that we've discussed many times. But having said that, Sonny, somebody gets injured on the job. They've been a good employee for years, and certainly, now all of a sudden they're being treated, in an unfair way, or at least they think it's unfair, and suddenly and shockingly they get fired from their job or laid off in the midst of the potentially filing or being in having a workers' comp claim. What happens in that scenario?
Well, if they're back to work with restrictions and they get laid off or furloughed, I can file a claim to get them back on compensation, because the theory is they're suffering a wage loss again as a direct result of their work injury. But as Faye indicated, they may also have a employment law or discrimination claim arising from a discharge following a work injury, though those claims tend to be difficult to prove because no employer is going to admit that they fired or let you go because you filed or pursued a workers' compensation claim. That just isn't going to happen.
But if you've been working for a company you're working for a company for 15 years, you've had no issues, and you all of a sudden, you pull your back out, you can't, obviously, next thing you know, is circumstantial evidence enough to kind of make that move in the right direction?
No, because if I was the employer, I would simply say, listen, we don't have a job available to accommodate your restrictions. An employer is not required to make up work to fit within someone's work-related restrictions. That's the obvious response that an employer should make to that kind of claim. And unfortunately, we just don't have work that accommodates your restrictions.
Faye, and let's say Sonny contacts you and has somebody he feels has gone through something like that, what would be the hot buttons that you would look for in a workers' comp type situation?
Well, first of all, the employee has to be able to work in some capacity. And I'm seeing a lot of that with the COVID cases, because people call and they say, well, I'm not able to work, but I want to stay home, or I want to stay home because I don't feel it's safe to work. Can I still get paid? So something similar happens in workers' comp. I determine, and I'll just take one particular case. We had a man who was a mechanic. He got injured on the job. He was terminated right away. The employer did not even check to see if there was anything he could do or if there was some job that they could place him in. So workers' comp lawyers and civil rights lawyers don't always agree on this particular area of the law, because workers' comp lawyers have their specific rules and laws they have to comply with. But the Americans with Disabilities Act is a very strong act in the sense that it does require an employer to start engaging in something called the interactive process, which is you are supposed to ask the employee, is there something they can do, and is there some job that we can accommodate you in? So, for example, let's say there is some job where this person can do paperwork, or they have permitted someone else to do paperwork where they didn't have to do the physical job they did before. If there is that type of a job, they are supposed to try to accommodate them. They don't have to create a new job, but they are supposed to have a conversation. What can you do? What can't you do? You can ask their doctor what they can do. And possibly there's some work that they can do. Now, workers' comp lawyers don't always like that, because then they're saying, well, wait a minute, this person is supposed to be paid for not working. You've got them working at this other type of a job. So we always have to be careful to see what we want to juggle. But sometimes what we do is we establish another type of settlement where we say to the employer, all right, there is a job we feel they can do. You don't want them to do it. So come up with some kind of a severance package if you don't want this person to work at your facility. So that's how we sometimes negotiate that. They are not huge settlements because there's already a workers' compensation payment issue happening, or they're being paid, or they're going to settle for that. But we have negotiated many issues with the employer for just saying, oh, you're injured, goodbye. They are not supposed to say that. So we approach it from a little different perspective. And also, once the workers' comp claim is finished, can that person return to employment if they're able to? And if the employer has precluded that by saying you're terminated just because you were injured, they can't do that under the law. They have to make a determination if there's some work that can still be done when that person is able to return. So I have something like that now where a person needed surgery. They were laying off for COVID. He was one of the top managers. They said, you know what, we're going to have less people employed. Your injury makes it impossible for you to return, so you're terminated. Now, his doctor next month is going to tell him whether he can go to work. He no longer has a job to return to work for. So we are approaching the employer saying, look, you violated the law. You don't need him back, but pay him something as a severance package on top of workers' comp.
Hey, does any injury fit within the definition of disability under ADA?
That definition has been expanded over time, and it's really a case-by-case basis, even to the extent where we've expanded it to the point where we say, look, if someone says they are suffering from depression, although they may not have even been diagnosed by a doctor, if you, the employer, think there is a problem and you just terminate them without suggesting that they receive some medical treatment or get a report from a doctor, then you have violated the ADA, although there isn't even a defined injury. So over the course of time, courts have expanded what is considered, like a material health condition or a major health condition. That has become very diminished over time. And as I said, sometimes there doesn't even have to be a formal condition. We raise it, and we say, look, employer, you thought there was something problematic. This person's been a nurse for 25 years. She's all of a sudden just messing up all over the place. You have some duty to say to her, something doesn't seem to be right. Are you having a problem? Now, employers have a problem with this because they are concerned about privacy rights. So, and sometimes I think they're overly concerned because we've had instances where the employer doesn't want to know about the medical condition, but still continues to discipline our client because our client is getting benefits from a third-party carrier. So it becomes a mess. So no, I think what the definition of a disability has gotten greatly expanded.
So the injury doesn't necessarily have to be permanent without the possibility of recovery.
No.
Okay.
I don't feel that. I mean, as the law is the law. It's basically a statement. As you know, it's fleshed out and developed by cases that have made their way into the legal system and how judges have interpreted the definitions. And the Americans with Disability has been expanded over time, and it's a very tough law.
Yep. All right, we're gonna pay some bills. We're gonna have more from the Pain and Wellness Hour with Sonny Banks and his guest Faye Riva Cohen after the break.
My friends, this is Joe Kraus. You've heard me on Philadelphia radio now for over 20 years, and you know I don't often endorse products or people unless they are real game changers. I want to tell you about Weinerman Pain and Wellness, located in Center City, Philadelphia. And at the end of this short personal endorsement, I want you to consider Weinerman Pain and Wellness. If you are recovering from an injury, if you or a family member has been diagnosed with a disorder that has stopped you in your tracks, or if you're like me, determined to learn about wellness while getting yourself prepared to stay healthy so you can enjoy the blessings of your family. Remember the name of this warm and caring location, Weinerman Pain and Wellness. Why should you consider Weinerman Pain and Wellness? Because they are who you expect them to be.
Weinerman Pain and Wellness, located at 1617 John F. Kennedy Boulevard, Suite 1100, Philadelphia, PA 19103. Call Weinerman Pain and Wellness at 215-988-9503. That's 215-988-9503. Call today.
Every day, the men and women of the United States Marine Corps demonstrate their commitment to defend the American way of life. Since 1775, we have served our nation as a force in readiness. From combat operations to humanitarian assistance in every corner of the world. No matter where the mission takes us today, or wherever our country needs us tomorrow, we always remember the land we call home. As Marines, we take a stand for each other, For our nation. For us all. The few. The proud. The Marines.
It's Thursday night, and you're grabbing drinks with some friends. Started off with a pitcher for the table, which quickly becomes two. There's pool. And there's the photo booth.
All right, everybody squeeze in. Say cheese!
Followed naturally by an order of wings. And another.
Can we get some extra ranch sauce?
Then there's the ceremonial nightcap.
So what are we doing this weekend?
And lastly, it's back to the car, which, if you're buzzed, could be the most expensive night of your life. Getting pulled over for buzz driving could cost you around $10,000 in fines, legal fees, and increased insurance rates. Nothing kills a buzz like getting pulled over for buzz driving, because buzz driving is drunk driving. Brought to you by the National Highway Traffic Safety Administration and the Ad Council.
They just told us right away that we're gonna house you, we're gonna feed you, and every single one of his medical bills is just all taken care of.
They've saved my family from financial ruin. It allowed me and my wife both to focus on the most important thing, which was the health and well-being of our son.
We have phenomenal research, outstanding clinical care, and the generosity of public, which allow us to treat patients regardless of what it takes. And that's what makes St. Jude so magical.
At St. Jude Children's Research Hospital, families never receive a bill for treatment, travel, housing, or food, because the only thing a family should worry about is helping their child live.
Doctors send us the toughest cases to be treated at St. Jude, and our patients come from all over the world.
When we come here, they told me, don't worry, everything's being taken care of.
We could never repay St. Jude for what they've given us.
Because of you.
Gracias a ti. Because of you.
There is St. Jude.
All right, ladies and gentlemen around the Delaware Valley, welcome back to the Pain and Wellness Hour with Sonny Banks, sponsored by Vitamin Pain and Wellness, serious doctors for serious injuries. I'm your co-host, Joe Dougherty. If you have an injury of any type, call into the Banks Law free consultation line, 215-696-0760, or contact Sonny directly by email at hbanks@bankslaw.com. The website is bankslaw, www.bankslaw.com. We're having a fantastic conversation with Faye Riva Cohen. We're talking about all kinds of situations. Sonny, one of the things, I wanted to kind of, put by Faye is that if somebody feels like they're being harassed on the job, or they feel like they're being set, not even if it's an injury, but if they're being discriminated against for any reason, Faye, is there documentation they should start? In other words, once they see this going on, instead of obviously, like you mentioned, trying to, make a big stink about it, is there, if they feel like they're going through something, should they document it and try to put as much information together as possible before they call you, or and my suggestion would be simultaneously contact an attorney like yourself so that they understand the right things to do, so they can recognize those situations while they're happening. Is that accurate?
Definitely they should document their issues. However, many people document their issues on their office computer. And so
not a good idea.
No.
People believe that their office computer is their computer. It's not. It's the employer.
Oh, that's right. We have all sorts of things on there. We have family photos. We have pornography. We have whatever is on there. But
no, I get it.
Right, and you know what else is on there? Their employment agreements they signed, their non-competes, their performance evaluations. So if they're terminated and asked to leave that day, they don't have access to any of those things any longer. Their employee handbook, their policies, they don't have access if they are on your office computer. So if you can and you're permitted to download those or print those documents or take them out of the workplace, do that. Make sure you have a copy of any document you have been asked to sign when you begin your employment. And make sure you have a copy of the signed part of the documents, not just a document, but what you have signed, what your employer might have countersigned. Employee handbooks, those have sort of gotten, outdated. They're not always in writing anymore. But if you have access to those policies, at least dealing with disability issues or discipline issues, download them or transfer them or copy them. As far as if there is an employee file which is maintained for you, it may be in HR or it may be in your supervisor's. Every office, every so often, ask to see if you can look at that file and see if you can make a copy of what is in that file, because once you are terminated, you no longer have a right to receive a copy of anything in that file. And
I wasn't aware of that. So employees do have access to their personnel file
while they're employed.
Right.
But if they're terminated, they can't get a copy of what's in that file unless they go to court or have some subpoena authority. Then they can have a copy. And the other thing is, if you look at your file every so often, you know what's in there. If you're terminated and all of a sudden a document appears that you never saw, it could have been placed in that file to support your termination by the employer. So
Right.
that's important. Keep a copy of your collective bargaining agreement to see what your benefits are. Many people don't have those. Make a copy of your performance evaluations or any discipline notices. I am just shocked at how little people have as far as paperwork available to them. They remember things happen to them. They don't remember the date. They don't remember this or that. You need to prove your case. So that's a form of evidence, and you need to look for that. You can keep your diary, but keep your diary at home. Don't leave it in your desk in your drawer at the desk. If you're terminated, you may be asked to leave that day. That doesn't mean your employer hates you. They're not being terribly cruel. It just means they're concerned about whether you create bad morale for other people, whether you're going to start yelling or carrying on or becoming extremely upset, whether you may commit violence against someone in the office. So that's why you're asked to leave that day. And when you leave, you don't generally have a right to take anything out of your office. You normally have to arrange that at a later date. Or you don't have a right to pull everything off the computer. So I've had many people who cannot access family photos ever again. So as long as you have that information, you have it at home. Don't take secret policies out of the workplace and bring them home, which a lot of people do. Right. But just keep a record, keep a diary, keep it every day. If you have something to say, and document it. If you report something to HR or you want something investigated, get a copy of it. Sometimes you're able to access any investigation that they do, sometimes not. So as much information as you can, keep a copy of it. That's a very good point.
Do you often have an issue with, I'm going to take a shot at this one, but with getting witnesses, if somebody's, obviously, even if it's a blatant situation, having said that, sometimes other employees, I'm sure likely are not easily willing to testify at the fear of losing their own jobs.
Sure.
Well, it's true. I mean, that is usually the case, and I've seen many people at trial just lie through their teeth, and I can tell they're lying because there are telltale signs. Sometimes they start blushing, sometimes they start stuttering, but they're worried about their job, or they have tremendously selective memory all of a sudden.
Oh, yeah. Well, you mentioned something a little while ago that I thought that rang a bell, and a non-compete. If somebody signs a non-compete, and I know there's a million different types of language that could be in there, but and they're terminated for whatever reason, even if it's not a good reason, does a non-compete still typically is it still in effect?
Generally, it is. Non-competes are undergoing a change. they may at some point be wiped out altogether if the state legislature decides that they want to make a change. They are becoming less popular. Many people who have entry-level positions and are not being paid very much are being asked to sign non-competes, and that's really not fair. And also, if you are asked to sign a non-compete at the beginning of your employment, and then in the middle of your employment or a couple of years down the road you're asked to sign another one, Pennsylvania state law generally requires that you receive something called consideration. You receive something in addition than your regular salary for signing a new non-compete. Sometimes a new company comes in, they merge, they want you to sign a non-compete with them. They generally, without the authority to offer you more income or possibly something else like more benefits or promotion, they don't have to force you to sign it. Now, sometimes there are issues and you say, I'm not signing it, and they say you're terminated, then you have to deal with that situation. But yes, they are still valid in many areas of the country and in parts of Pennsylvania, and many people don't know what they sign because, or they don't feel they have a choice. You want a job,
right?
You sign a non-compete, and the other thing that's being litigated often these days is whether you have a right to jury trial. If you have signed a non-compete or other agreements saying that you have to arbitrate or mediate your claim. So that's an issue that is being litigated these days, although I think with COVID there aren't going to be as many jury trials, if any, going into the future. They have to do something about the distancing issues.
We've talked obviously about civil rights, and we got about probably 5 or 6 minutes left, and we've obviously talked about situations with employment. When it comes to family law, and you talk about COVID, and the quarantine. Me and my wife we have a 34-year-old son, so he comes over for dinner occasionally. But we've been locked in the house together pretty much for the last 4 months, and
and Joe, you have to add, you're enjoying every minute.
Every minute of it, Sonny. It's a great point that you make. I specifically, when I researched Faye, made sure my wife wasn't. I was going to have her listen, and then when I saw the name of the blog, I'm like, you know what? Elaine, we're playing a rebroadcast today.
Right.
But having said that, now more than ever, family law situations have come into play, and I know that you handle the family law situation. Do you handle a decent amount of divorce law, and if so, right now is it, since there's so much stress in this world, how's that being impacted?
Well, I think there's a reason the family courts have closed.
Oh, yeah.
There you go.
We're not busy. I mean, we're busy. You've reached.
I think there'd be a flood of people running in there, honestly.
Right.
I think the divorces are just going to boomerang. We have just starting to get a lot of calls about divorce. For a while, it was just sort of sitting there, and then people would call and we'd say, well, the courts haven't opened yet, so there's nothing to file yet. But now I'm seeing every day we're getting a lot of divorce calls. There are also issues about custody and visitation because mom or dad doesn't like the way the other one is handling the kids,
right?
Whether they're isolating them enough or social distancing them enough. So if the court opens to the extent that it should, which it hasn't yet, and I don't even know when people are going to get into the courts to discuss these issues, and that's going to be another huge problem. So we are in for some very problematic times ahead. One of my lawyers, Jim Cushing, who handles family law in the firm, went to court for the first time the other day, and he said there was him, the other attorney, and the judge. No one could hear each other because they were wearing masks.
Oh, yeah.
You could only have 3 people. And you know the family courts have thousands of people around. 3 people could come down in an elevator, a specific appointment. They're going to be backed up for years. So I'm not sure what you can do, but I know the family counselors are happy because they're working through Zoom. But,
right. No, there's no question about it. It's
right.
You know.
It's a stressful time for all of us. Let's just hope we all are able to stay well and, get through it.
Sonny?
And Faye, I had something that I wanted to ask you earlier. You mentioned that you do some estate work, and you said that people should have 3 things: a will, a power of attorney, and a living will. I've heard others, suggest that you need a will, but not a power of attorney. What's the importance of a power of attorney?
Well, a will only takes effect once you've passed on. So if you're alive and, God forbid, go into a coma or you have an injury and you're in a hospital, even if it's a broken leg or whatever, and you just can't get around. You can't get to the bank, or you don't have electronic banking, or you can't go and manage your real estate, or you're in the middle of a sale and you can't get to a settlement. A power of attorney takes effect when you're still living, and that is the difference. But I cannot tell you how much confusion there is, and people think, oh, well, I'm married, so my husband or wife is my automatic power of attorney, or my child. No, that is not the case. There's also a huge amount of fraud on the powers of attorney, which can be changed as long as someone's lucid. You can change it every day. So definitely get those documents in place and make sure to check on them every so often. Make sure they are in the form they should be in Pennsylvania. People sometimes use Zoom and download forms. They may not be valid in Pennsylvania.
So we have about 30 seconds left. If you would, Faye, the contact information at the firm?
215-563-7776, or my email is my initials at my full name, so it's FRC@FAYERIVACOHEN.com.
Awesome. Sonny Banks, real quick, your contact information?
Banks Law, 215-561-1000. Web address, www.bankslaw.com. And I want to thank Faye for appearing today. A very, very informative show.
Thank you so much, Faye. Fantastic information. To our listeners, you've been listening to the Pain and Wellness Hour with Sonny Banks. We want to thank everybody for tuning in. We're sponsored by One Man Pain and Wellness. I'm Joe Dougherty. Thanks for listening.